Hello and welcome to another very important session. Today we'll discuss something which touches upon the consequences of making false statements in affidavit. We will also see what is the procedure related to the same. I'm Rohit Rohila, and on behalf of LiveLaw Academy, I welcome all of you to another very important session. So recently there was a matter before the Orissa High Court in Priyadarshini Amrita Panda versus Biswajit Patil. It was a matrimonial issue. The case was related to maintenance. And the wife alleged that the husband has made some false statements in the disclosure affidavit. Now, the disclosure affidavit is an affidavit which is which lays down all the assets and liabilities of the parties, and it is submitted in matrimonial cases, particularly in cases related to maintenance. And now it is a mandatory practice because there is a Supreme Court, rather two Supreme Court judgments to this effect, Rajneesh versus Neha and Aditi versus Jitesh Sharma. So it was alleged that the statement in the affidavit submitted by the husband to the effect that he is the only son was false. Also, another statement in which he claimed that his father is dependent upon him for his maintenance was also false. It was alleged that the father of the husband is an advocate, a reputable one, with a stable income and landed properties. So it was claimed that the husband should be prosecuted for the offense of perjury. When the application was made to this effect before the trial to this order, against this order, an appeal was made before the uh, Odisha High Court. So why there was a need to make an application to prosecute the husband for perjury, and then it was submitted before the High Court that at least the trial court should have made a preliminary inquiry into the same. So what is the procedure around the preliminary inquiry? Where does it come from, and whether it is mandatory or not? All these things will be answered. Let's understand the offense of perjury first, right? So the offense of provided under sections 191 to 193 of Indian Penal Code. And these sections have now become 227 and 229 of Bharatiya Nyaya Samhita. 191 and 227, they are the defining sections, and the other two are the sections which prescribe punishment. So let's see section 227 of BNS. That is where the definition of the offense is provided. Let's see 227, giving false evidence. Whoever being legally bound by an oath or by an express provision of law to state the truth, or being bound by law to make a declaration upon any subject, makes any statement which is false and which he either knows or believes to be false or does not believe to be true, is said to give false evidence. Now, from this definition, one thing is clear, that it does not matter at all whether you are giving a false evidence with respect to a fact which is material to the proceedings. The only thing that section requires is a mens rea, and it simply does not matter whether the evidence was given in the context of a very important issue in the case or a peripheral issue, right? Then the question here which arises, whether affidavits are covered by this section or not, right? Let's see the opening words of the section again. What does it say? Whoever being legally bound by an oath. Whoever being legally bound by an oath. So these words clearly provide that affidavits are very much included. They are very much covered by this provision. And there is a case of Honorable Supreme Court to the same effect. Ranjit versus State of Pepsu. Right now, it has become Punjab, right? So Ranjit versus State of Pepsu, AIR 1959 Supreme Court 843. In this case, the accused was a police officer. He was asked to submit a reply against an application under Article 226 of our Constitution, where it was alleged that he was responsible for illegally detaining a person. And in his reply, he filed an affidavit making false statements in that, stating that the person was never arrested and consequently never detained. But ultimately, these statements were found to be false. So the court said that he was under an obligation to state the true facts before the court, and he has not done it. He has intentionally made false statements, and an offense has been made out under this section. The court referred to 191, the previous defining clause section. Now it is 227 BNS. Same thing is provided. Right? Now let's discuss the procedure related to it, to such cases. In such cases, the courts are not empowered to take cognizance unless there is a complaint in writing made by the court. There is a limitation on the courts taking cognizance. See, cognizance can be taken either upon police report or complaint, oral or in writing, or upon any other information, even suo motu, right? But in such cases, the cognizance can only be taken when there is a complaint, and that too in writing from the court, or from some officer authorized in this behalf, or from a superior court to which the court was subordinate, in which the offense was committed. Right? There is a provision in BNSS, and the same provision was there under CRPC. Now it has become section 215. Earlier it was 195. Let's see what is provided. Let's see. See, 215. It is a provision under the chapter related to cognizance. See the title: Prosecution for Contempt of Lawful Authority of Public Servants for offences against public justice and for offences relating to documents given in evidence. Right? Come to B. Subsection 1, clause B. See. Any offence punishable under any of the following sections of Bharatiya Nyaya Samhita, namely sections 229 to 233, both inclusive, and we have seen that 229 is related to what? Punishment for perjury. Right? Then what is provided? See here, cognizance cannot be taken in such cases except on complaint in writing of that court or by such officer of the court as the court may authorize, or some other court to which that court is summoned, that is a superior court, right? So unless there is a complaint in writing, cognizance cannot be taken. Here it does not mean that that investigation cannot be made in such offences. Investigation can be made, but when after completing the investigation a police report is filed, the court is not empowered to take cognizance, though it can take the same into consideration for the purpose of deciding, right, whether to go make a complaint in the matter or not. But on the police report, cognizance cannot be taken. There has to be a written complaint from the court or from the officer authorized by the court or a superior court. Then the provisions of section 215 are to be read with section 379 of BNSS. Earlier, 379 was section 340 of CRPC. See the title of the chapter again, provisions as to offences affecting the administration of justice. Procedure in cases mentioned in section 215. When upon an application made to it in this behalf or otherwise. So the application was made in the matter before the Orissa High Court. It was made on behalf of wife, right? That is why an application was supposed to be made. So one question is answered. Upon an application made to it in this behalf or otherwise, any court is of opinion that it is expedient in the interest of justice that an inquiry should be made into any offense referred to in 1B of 215. We have seen it includes perjury, which appears to have been committed or in relation to a proceeding in that court, as the case may be, in respect of a document produced or given in evidence, etc., etc. Such court may, after such preliminary inquiry, if any, as it thinks fit, as it thinks necessary, record a finding to that effect, make a complaint thereof in writing, and rest of the procedure. That then it will be sent to the magistrate who has the jurisdiction, right? And the case will proceed. So, in such cases, the cognizance cannot be taken unless there is a written complaint from the court. And in order to make a complaint, in order to initiate the proceedings, the court must first decide whether it is in the interest of justice or not. Section 379 gives a wide discretion to the court, and that discretion has to be exercised judiciously. So in every matter, it has to take a call whether to proceed with the case or not, whether there should be a formal written complaint in the cases of perjury or not, because the same can have serious effect, right? And given the kind of legal literacy we have, it is a good thing to do, to look at the effect of giving the false statement in a given case, whether it was serious or not, right? And this has been laid down in numerous decisions before the Supreme Court, in numerous decisions rendered in the cases before the Supreme Court. And one such case is Ashok Kumar Agarwal versus Union of India, AIR 2014, Supreme Court 1020. In this case, the Supreme Court said that unless the court finds that there was a deliberate attempt to deviate the court from the course of justice, to misguide the court, then only written complaint should be made. The discretion provided by the section should not be exercised very readily, right? Now comes the issue of conducting a preliminary inquiry. We have seen in section 379, the words preliminary inquiry, they were mentioned that after conducting preliminary inquiry as it deems necessary. So the question is whether it is mandatory to conduct such a preliminary inquiry or not. So in the case before Odisha High Court, in the appeal, it was submitted on behalf of the wife that the trial court should not have rejected the application, and at least they should have it should have conducted a preliminary inquiry. So the matter is whether it is mandatory or not to conduct such preliminary inquiry. Going by the words of section 379, we have seen the words clearly indicate that it is not mandatory, and the same has been upheld by the Supreme Court in number of decisions. Two important decisions I'm telling you: Pritish versus State of Maharashtra, AIR 2002, Supreme Court, page 236, and State of Punjab versus Jasbir Singh, 2022, LiveLaw, Supreme Court 776. In these cases, the court has clearly held that it is not at all mandatory to conduct such preliminary inquiry. In fact, it is not at all necessary to give notice to the accused. If the court thinks fit that it is in the interest of justice to initiate the proceedings, the court can straight away start with it. And if it thinks that the case is not made out, it was not very serious, then the court can decide otherwise. And there is no need to conduct preliminary inquiry in either of the cases. It is completely in the discretion of the court, right? So, in the instant matter before the Odisha High Court, the Odisha High Court upheld the decision of the trial court that there was no need to conduct such a preliminary inquiry as a mandate. Also, the facts that were alleged by the wife regarding the false statements, they are questions of fact, and they can be decided. One can decide upon them only when the trial happens. So it was kind of a premature, right? These things can be decided one way or the other way during the trial as well. So the court rightly held that the petition for initiation of criminal proceedings deserved no positive consideration at this point of time, right? You see, sometimes people believe that they can get their way to the victory by lying in the court. And the only thing that they end up winning is a one-way ticket to the jail. So these things should be approached with seriousness, and these provisions and decisions, they clearly indicate that we should make responsible pleadings before the court, including the statements we make in affidavits. So that's all from my side as far as today's session is concerned. We'll meet again. Till then, goodbye, take care, have a very nice evening.